Chainsaws and an inflatable pool ordered online, prosecutors say it's evidence in the death of Celeste Rivas Hernandez and in the prosecution of David Burke, also known as the singer David. It all came out in court this week. We'll get into that, plus the latest in the Nick Reiner prosecution for the murders of his parents, Rob and Michele Reiner, and a pretty extensive outline of what we should expect at the upcoming trial of the man who's accused of causing the Palisades fire. Prosecutors dropped their trial memo, which is a summary of what they plan to do when the trial begins and jurors are listening. It's the Leonard Files podcast for Friday, May 1st, 2026. All kinds of stuff happening in court today, or in court this week. But really, it was a week of delays because there was an expectation that the case against David Burke, the singer David, was going to go to a very speedy preliminary hearing today, Friday, May 1st. It's not happening. I'll explain why. Nick Reiner, who's accused of murdering his parents, the director Rob Reiner, his mother, photographer Michele Reiner, he was in court, and we thought we would get some kind of action that moved the case a little more quickly towards a trial. The opposite happened. It got put off for months. I'll explain that. And then lastly, in the case of Jonathan Rinderknecht, the now 30-year-old man who's charged with federal arson charges, accused of igniting the first of the two fires that eventually caused the Palisades fire, the case is moving towards trial in June. But there's some back and forth going on between prosecutors and defense lawyers about exactly what it is that jurors will be allowed to hear in the case, and so that could potentially lead to a delay. But let's start with the case against David Burke. He was in court on Wednesday because his attorneys, ever since he was arrested and brought to court and charged with the murder of 14-year-old Celeste Rivas Hernandez, charged with the continuing sexual abuse of a minor for about a year prior to her death, and also charged with the mutilation of human remains, his defense lawyers had been pushing the court, the judge who held the arraignment and the initial appearance, and then the judge who will eventually preside over the preliminary hearing and possibly a trial. The defense was pushing them to get this case to a preliminary hearing stage as quickly as possible. Under the law, you are, as a defendant, entitled to a preliminary hearing within 10 days of your arraignment. But it rarely happens, and it rarely happens especially in complicated felony cases, let alone a complicated murder case, because there is virtually no opportunity within that 10 days for the defense team to become completely familiar with all of the potential evidence that prosecutors might bring up at a preliminary hearing, which is the test of a case. It's the first test outside of law enforcement, now in front of a judge, the judicial branch, where the prosecutor has to explain to the judge that we don't just say this person is guilty of this crime, we have the evidence to prove it. And even though it's not a full trial, they generally have to show some indication of what it is that backs up the accusation. And then it's the judge's job to decide whether or not the case moves to a jury trial. In practice, it is a very low legal threshold. This is not beyond a reasonable doubt. This is just showing that the case isn't a complete fiction. And it's a protection for all of us that the government, the executive branch, can't just go after you and lock you up for months or years on end without a demonstration that there is actually evidence to back up the charges that you're being held on. So, rarely do these things happen within the 10 days because rarely, again, in complicated cases, especially murder cases, have defense attorneys had the opportunity to even get a hold of, let alone review, examine, interrogate, investigate the potential evidence that prosecutors intend to present in court. So, it's something of a legal strategy, perhaps, that a defense team or a defense attorney would insist on holding this hearing within the 10 days. The strategy might be, well, maybe the prosecution's ideas about the case or the tests on potential evidence haven't been fully formed yet. And if we can force them to show their hand, meaning force the prosecution to show their hand quickly, maybe it'll be a demonstration that there isn't a there and the case kind of falls apart. This is largely what the old TV series Perry Mason was based on, was the idea that you get into court very quickly and a savvy and smart defense attorney might be able to show there are so many holes in the prosecution's case that either there is no evidence, the person's innocent, at least in Perry Mason's case, the person was almost always innocent, but that the case couldn't proceed, the charges are dismissed, everyone leaves, and freeze frame on smiles all around. But again, it rarely happens in real life because things are more complicated than on TV. And I say that as someone on TV. So we were in court this week on Wednesday because there was going to be a preliminary hearing ahead of the preliminary hearing within the 10-day period so that all of the lawyers could discuss whether or not the defense would be ready to proceed today as we record this, Friday, May 1st. And lo and behold, as we kind of knew and everybody knew, the defense said it wasn't ready to proceed. It had not obtained copies of the key evidence in the case. It had not seen the full coroner's autopsy file. It had not even begun to look through what we learned and reported earlier this week were 54 search warrants obtained by police that produced all sorts of potential evidence. We heard a lot of them had to do with digital material, like cloud accounts and phone records. And we know that Celeste Rivas Hernandez's remains were in a Tesla, so it stands to reason that the digital records that may be held on Tesla's servers were one of those warrants. 54 is a lot, by the way. Complicated cases, there can be dozens. But just in my casual poll of homicide detectives, they said, yeah, that seems like a lot. So they come into court Wednesday, and again, the defense is saying, yep, guess what, Your Honor, we're not ready to proceed. And so there was a moment where the prosecutor on the case, Deputy District Attorney Beth Silverman, works out of the Major Crimes Unit. You may remember her name because she has come up a lot in the stories that we cover. She handles a lot of very interesting, mostly murder cases. And she says, Your Honor, we are ready to proceed. We, meaning the people, the prosecutors, are ready to proceed. We moved mountains, I'm paraphrasing, to get everything ready to go to a preliminary hearing on Friday. She says people's schedules were changed. Witnesses were being brought in from out of town because the defense was insisting we hold this hearing Friday. Your Honor, we demand that the hearing go ahead. And the judge says, yeah, well, they haven't seen all the evidence yet. That's a good reason to delay it. So the preliminary hearing has been delayed until May 26th. At the earliest, there's a status conference on May 12th. That's when they'll get back together and have another one of these discussions about whether or not the defense really is prepared to go ahead on May 26th. Preliminary hearings are usually very short, usually a couple of days at the most. This one could go on a little bit longer, and the judge warned everybody. She said, look, my courtroom is going to be closed the first week of June. So if this preliminary hearing, scheduled to begin on the 26th, were to last more than a couple of days, we would have to take a break and come back. And they had to get the agreement of everybody involved, the prosecutor, the defense attorneys, and the defendant himself. So I was in court for this hearing. It happened at 1:30. This is up on the 9th floor of criminal courts in downtown L.A. The 9th floor is where the most serious felony trials take place. There's an extra layer of security to get into the courtrooms on the 9th floor. In cases where there's a lot of interest, the seating is controlled. We got our seat. It was sitting next to someone from ABC and from one of the other local TV stations. And David Burke gets brought out. You may remember, if you were following our television coverage, that one of the things the defense had asked for was that he get a shave and a haircut prior to his appearance at the preliminary hearing on Friday. It looked like that happened before he appeared on Wednesday because, in fact, the judge signed that order directing that those things happen. The judge denied a request that he appear in street clothes. The defense wanted him in a button-down shirt and some kind of slacks. The judge said no. And then the judge agreed to unseal, for the purposes of the defense, those 54 search warrants that I mentioned. So that's what mostly happened during the hearing. But the last thing that happened will lead to all of the revelations that we reported on this week having to do with this case. And it has to do with a memo that the prosecution presented outlining what it was that would be presented at this preliminary hearing. It's like a trial brief is the wrong word because it's not a trial, but it's a preliminary hearing brief. And it's a few pages long and was a description, an outline of the evidence and potential witness testimony that might play into the presentation in court. And before we even saw the document, the defense tried to block it from becoming public. Blair Burke, the lead of the three defense lawyers who are representing David Burke, said, "Your Honor, this is all very one-sided. The evidence that is being presented in this document has not been admitted into court. It has not been tested. And out of the defense's concern with eventually finding a potential jury pool that could be fair about this case, the defense lawyer said, you got to keep this under seal. You cannot let this out." So I'll get to how that played out after I tell you about what's in the document. And, spoiler alert, since we're talking about the document, obviously the defense did not prevail in the request to have it withheld from public view. I should warn you that some of the descriptions that we're probably going to go through in the next couple of minutes may be upsetting or disturbing because it relates to the abuse of a child and her murder, the mechanism of that murder, and the mechanisms of what prosecutors believe David Burke did after the murder, which may be even more disturbing than anything else. So, according to this document, and I can show you just the cover of it. I'm not going to show the whole thing because there's some details I just wouldn't want to put out there. But here's what it looks like. It's I can't exactly tell how many pages it is from here, but it's a handful of pages, and it talks about all of the potential evidence that the prosecution may present. How many pages is this? It's about 7 pages of actual text. And again, filed by the deputy district attorney who's been assigned to this case, Beth Silverman. So the first part of this is it begins to lay out how it is that prosecutors know or believe, and police believe, that David Burke, a.k.a. David the Singer, is responsible for Celeste Rivas Hernandez's murder. The first thing it says, and again, this may relate back to those search warrants that we were talking about, that David Burke, the guy accused, was the last person to drive the Tesla Model X sedan, the black sedan, before leaving Los Angeles on his concert tour. They say he drove it on July 29th, 2025. Now, if you remember, her remains weren't discovered until September 8th, 2025, and that followed that Tesla sedan being impounded from a street in the Hollywood Hills. Prosecutors say it was 400 feet away from the house that he had been renting. I thought it was further, maybe not. And they say they have information that he was the last person to drive that car July 29th, 2025, until it was impounded and opened, and her remains discovered more than a month later. That's piece of evidence number one, alleged evidence. The DA's office says it took 8 days to identify Celeste Rivas Hernandez. And one of the things we were wondering about was, how was it that the remains were identified even that quickly? Because in law enforcement, when there is a unknown individual, typically identifications can only happen if that person or their remains are compared to a known quantity, right? You compare them to fingerprint records that may be on file. You compare their DNA to a sample that has been provided by their family. But if you don't know what it is you're comparing it to, and you don't have an outside reference for that, it becomes very difficult. Now, this isn't like the movies where you can search the dental database for somebody's impressions and then make an identification. It's also unlikely that somebody's DNA profile would just be sitting in a database. The database that exists nationally and the one that exists in the state of California is mostly an offender database. It's based on people who have been through the justice system. It is not an archive of all of us just waiting to be identified through a DNA profile. And so without something to compare a unknown discovery to, it's very difficult to make an identification. So we learn now how all that happened. According to the DA's memo, Celeste Rivas Hernandez and David Burke met. It sounds like it was online, but we don't know for certain, when she was 11 years old. This would have been in January of 2022. So at least a year before we know that they had physical contact. The DA's office says in the memo that they began to have sexual relations when she was 13 years old in November of 2023. And that, according to the criminal charge, extended for at least a year until about November of 2024 as what they describe as a boyfriend-girlfriend kind of relationship. When that relationship began, Burke was 18, and when that relationship sort of ended, as we'll see, he would have been 19 in 2024. Celeste Rivas Hernandez, who died when she was 14 years old, identified by the medical examiner when she would have been 15 years old, and beginning this relationship with him when she was 13, was reported missing twice, according to the prosecution memo, once in February and once in April 2024 to the Riverside County Sheriff's Department. So this would have been some months into the alleged relationship that Burke and her had. Remember, it starts in October, November 2023, extends for a year. So she's reported missing now some months after she was gone from her family's home in Lake Elsinore. In mid-February 2024, again, according to the prosecution's document, the Riverside County Sheriff's Department called David Burke because somebody in her family probably knew that this was the person that she may have gone to visit or may be living with. Burke told detectives that he had last seen her in February of 2024 and claimed, again, this is according to the LA County DA's office memo, re-reporting other law enforcement records, claimed in February of 2024 he was unaware that she was a minor and he was unaware that she had been reported missing. Remember, 13 years old at the time. Eventually, the Riverside County Sheriff's Department gets the LA County Sheriff's Department to send some deputies out to the home where David Burke was living at the time, on Doheny Place. They get there that same day, the 17th of February, 2024. They door knock him and tell him to his face that the girl in question, who we now know is Celeste Rivas Hernandez, is 13 years old and had been reported as a runaway. 2 days later, she reappears at her family's home in Lake Elsinore. So this is where the two part ways for at least a little while. According to the LA County DA's office, and again, we're talking about this pre-preliminary hearing memo that's been filed outlining the potential evidence, Burke allegedly paid a high school student to give Celeste Rivas Hernandez a new cell phone so the two of them could continue having communications. Because you could only imagine, after law enforcement goes out to his house, tells him that she's a minor, she's a runaway, she's got to go home, or whatever else that interaction was. She shows up at home. Chances are her parents would not allow this relationship to continue. Maybe they took her cell phone away, so the prosecutors are saying Burke paid an 11th grader $1,000 to deliver a new cell phone to Celeste Rivas Hernandez. Prosecutors say through the remainder of 2024, she continued to spend a lot of time with him, going back and forth between Lake Elsinore and a rental home in Hollywood Hills. And then they say she also went to Las Vegas, to London, and to Texas to meet his family. You may remember in our discussion last week, Burke was back in Texas sometime after his tour got canceled and her remains were discovered. We know that his family members, his mother, father, and brother, were subpoenaed at their home in Texas to come out and testify about what they knew about all of this. Now we know why their testimony may have had so much relevance. It's not that you may have talked to David Burke about this thing or that thing. Prosecutors are saying that she, the victim, was at the family home in Texas, or at least visited the family home in Texas at some point. According to the timeline prosecutors lay out in this memo, in November of 2024, Burke cuts off the relationship with this now 14-year-old girl. And even though they maybe were seeing each other less, prosecutors say they continued to communicate online, and according to those communications, continued to have sexual contact. So just backing out of here, reading between the lines of the language that's in the document, it definitely makes me believe that some of those search warrants produced not only the communications, but possibly also imagery that backs up what they're saying. The DA's office says the two of them, the 14-year-old girl and David A. Burke, had an argument via text message on April 22nd, 2025. So we've now jumped ahead a few months in the timeline. And then all of Celeste Rivas Hernandez's cell phone activity stops on April 23rd, 2025. Prosecutors say that is the likely date of her death. And this was also 2 days prior to the release of David Burke's first studio album. Because remember, he was about to leave on a concert tour when all this happened. His career's kind of blowing up. He's become this sensation on TikTok. And the timing of this is probably what prosecutors would argue to a jury begins to form the motive and the stressor that caused all of this to happen. It says that at 8:40 p.m., April 23rd, 2025, David Burke sent an Uber to Celeste Rivas Hernandez's family home in Lake Elsinore, and he has this Uber driver bring her to the home he's renting in the Hollywood Hills. She arrives at 10:10 p.m. So again, think about all those search warrants, the 54 search warrants that were executed in this investigation. Things are beginning to be locked into a very specific timeline because of some of the information that police were able to get. The Uber driver, the Uber account would have had very, very specific records about pickup times, drop-off times, who paid for it, and things like that. According to the prosecution memo, at approximately 10:30 p.m., defendant sent text messages to the victim inquiring where she was, and prosecutors believe this was part of defendant's premeditated plan to cover up the murder because they believe, the police and prosecutors believe, she was already dead at this time. Now, here's some detail that we didn't get to in our television coverage this week just because it's just too much to fit into a short story trying to summarize everything that happened. But according to the DA's office, in the same time frame when they believe she was murdered, David A. Burke allegedly drove up to Santa Barbara County, attempting to, these are their words I'm reading here, dispose of her property and destroy evidence. At about 11:30 p.m., Burke texted and called the victim's phone, again asking where she was, and prosecutors believe these were acts to set up a defense in the timeline after the murder. In other words, making these calls and sending these text messages to create a staged trail of information that would make it look like maybe she never showed up at the house. According to the DA's office, Burke drove his Tesla north on the 101 to the San Marcos Pass Road near Lake Cachuma and then returned to his home early the next morning. So this is happening at night and then back after midnight. Lake Cachuma, by the way, is where I covered another horrific child murder involving a boy who was at the center of a custody dispute between his parents, and the father drove him to the same spot and murdered his own son there. I don't know what this road or this area has, but it just seems odd that both of these things happen there. Anyway, after April 26, 2025, David Burke never attempted to contact Celeste Rivas Hernandez again. So, again, the prosecutor showing the absence, or what some people would call the presence of absence, the fact that something has stopped happening is also an indication of something that happened. According to the memo, Burke then ordered a shovel from Home Depot on April 24th, 2025, ordered 2 chainsaws from Amazon on May 1st, 2025, exactly a year ago today, and ordered a body bag, heavy-duty laundry bags, and a blue inflatable pool on May 5th, 2025, All purchases were made under a fake alias, Victoria Mendez. And not to belabor the point, but again, going back to all the search warrants, chances are the information that backs up these statements were the fruits of some of those search warrants to Amazon to get purchase histories, delivery histories, all that kind of stuff. According to the DA's memo, Burke drove back to the same part of Santa Barbara County on May 8th at 11:30 p.m., and then again on May 31st, 2025. And then they say that Celeste Rivas Hernandez's identification, a U.S. passport card, was discovered by a Caltrans worker in January of this year, 2026. This is the grisly part. Warning you once again. An expert, we believe this is from the coroner's office, was able to compare and make some sort of match with blue fragments that were found on her dismembered body to the blue inflatable pool that was purchased by David Burke in May of 2025. When we were reporting on the unsealed autopsy, there were blue plastic fragments that were found amongst her remains. And according to the DA's memo, police found the inflatable pool that still had evidence of human blood on it when they searched the rental home in the Hollywood Hills after Celeste Rivas Hernandez's remains were discovered. So, this was the memo that the defense was arguing should not be made public. And the defense attorney, Blair Burke, asked the judge to seal all of this because by this point, we had not seen this document, but she had. The defense attorney says, and these are just from my notes in court, I come to the court with a very serious concern given what I think could be characterized as the extreme media attention in this case. And the prosecution has appeared to file a rather unusual, in my experience, prelim brief that appears to be a very one-sided view of what is anticipated in this case. And she says, but no evidence has been presented by the prosecution. There's been no admissibility of that evidence. And we have a very real concern about the reasonable possibility of the jury pool at a future trial being tainted. So obviously the defense doesn't want this out. It sure sounds pretty damning. This is the only side of the case we've heard, of course. The prosecutor gets up and responds. This is Deputy DA Beth Silverman. She says, I've certainly never heard of the defense claiming that a people's filing is one-sided. I'm laying out what I believe the evidence is and what the people intend to present to the court during a preliminary hearing. Well, of course it's one-sided. It's an adversarial system. It has to be one-sided. The prosecution doesn't make arguments for the defense, and the defense certainly doesn't make arguments for the prosecution, or that would help their case. So the judge in this case, Charlene Olmedo, says, in this court's experience, the media attention is no different than other cases, and she's handled some pretty high publicity cases in recent years. She says any publicity concerns that the defense has, the defense can address with potential jurors, and that's the most, I'm reading my notes here, that's most often the presumption that's used. In other words, the jury pool is not presumed to be tainted by pretrial publicity. You can ask jurors and weed out jurors that you believe have been swayed by this when potential jurors are brought in, assuming we get to a trial, and they're being screened for jury service. The judge continues. So the court is not going to seal the people's prelim brief. It's clearly the people's position, so obviously it's going to be one-sided, just like a defense filing would be. So the scheduling in this case, the next event will be on May 12th. That's when the lawyers will come back to court. David Burke will likely be there, and they'll discuss progress towards being prepared for this preliminary hearing, which has now been set for May 26th. It'll probably happen then, but there's so much going on in this case. I have a feeling that the more the defense digs into this mountain of evidence. Remember, the deputy DA told the court there were some 40 terabytes of material between the results of search warrants on cloud accounts and downloaded devices, and there's wiretaps. We don't even know what the wiretaps involve, but we know they're involved in this case. There's grand jury testimony. The further the defense gets into this, the more they may want time to prepare for this preliminary hearing. On the other hand, the judge may not go along with that. Preliminary hearings are supposed to be short. They're supposed to be relatively informal. The rules of what can be presented are different than at a trial. It's easier to present certain testimony at a preliminary hearing because the bar that the judge is looking at is so much lower than the bar a jury looks at, which is proof beyond a reasonable doubt. All right, let's turn to the Pacific Palisades and the arson case that is being prosecuted by federal prosecutors in Southern California, the U.S. Attorney's Office. That case is inching closer to trial. It is set for June. Just this week, there were proposed jury instructions filed in court where both the prosecutors and the defense attorney get together and decide what it is that jurors will hear from the judge about how to interpret the evidence and the testimony that they see at trial. It's lengthy. Sometimes judges take an hour or more to read these instructions to jurors, but it tells them what they are supposed to do with everything they've heard in court. A lot of it's boilerplate. It comes from higher up court levels that produce jury instructions that everybody has to use. They must use, for the most part, uniform instructions unless they come up with a specific reason having to do with a specific piece of testimony or evidence, and then both sides oftentimes will add to this. So that was some of what was going on in court this week. But the most interesting thing for our purposes was the feds filed a trial brief. Much like the pre-preliminary hearing brief we talked about in the Celeste Rivas Hernandez murder case, in the federal system, prosecutors are typically required to tell the court what it is that will be presented at trial, and most importantly for federal judges, provide an estimate of how long the trial will last. Federal trials tend to be much shorter than state trials. They tend to be much more focused on specific things rather than a huge retelling of some specific event. A lot of times, the facts that jurors will be asked to consider are stipulated in federal cases where the prosecutors and the defense attorneys will agree, if there's no dispute about some things, that there's no need to call witnesses to establish those things for jurors. Witnesses take a lot of time. So stipulations allow both sides to just read a statement to the jury that say, the following things are accepted by both sides as true, and you, the juror, must agree and assume these are true for the purposes of your consideration of all the other evidence in the case. And the more they do that, the fewer witnesses that have to come into court and testify, and oftentimes the shorter the trial is. Federal courts tend to set pretty strict time limits for trials that I don't see in state court very often, and it really focuses the lawyers and causes them to make their cases kind of snappy. They happen fast. So, jury instructions, the trial brief. The trial brief provides a fairly rough outline with a little specificity about what it is that the government intends to present at trial and their anticipation of what the defense might do in response and their opinion about defense witnesses that may come into the case. The government, the prosecutors, say they expect their side of the case to last 7 to 10 days, which is federal criminal trial, 7 to 10 days. That sounds right for me. That's outside of jury selection and any jury deliberation. But we also got a couple of new insights into the prosecution case. We all know the basic premise of this case, which is that a now 30-year-old man, Jonathan Rinderknecht, is accused of igniting the first of the 2 wildfires in the Pacific Palisades in January of 2025. The one he's accused of lighting was called the Lackman Fire. It burned about a dozen acres on New Year's night. It's put out, and according to the ATF, reignites in the hurricane-force winds that come up 6 days later, and then it explodes into the Palisades fire. The government has been looking to establish a motive. I'm not sure if this is really aimed at the jury or aimed at us, who, of course, are monitoring all of the filings in the court, because motive is not really something that they have to prove in court. It's nice to know, and sometimes it helps with telling a compelling story to the jury, but it's not really an element of the crime. They have argued that Rinderknecht had become angry at the point he was in his life. Relationships weren't going well. His job wasn't going well. And they say he became upset with society on the whole. And this is the new part. They say that he fixated on Luigi Mangione. That's the man who's accused of murdering the CEO of United Healthcare in New York, who became something of a, I don't even want to call him a folk hero, but became the focus of a lot of online attention for what he says his motives were for going after the head of one of these big profit-making corporations that has a wide effect on lives of people who are not as well off. They allege that Rinderknecht, this is the prosecutors back to this case, allege that Rinderknecht was searching for terms like, let's take down all the billionaires, let's kill all the billionaires, in the time frame that led up to the arson. They're going to argue that he had a fascination with fire, and they plan to call an arson expert. They plan to call a bunch of different arson experts at the trial, but one in particular to testify that there are some common themes observed in arson cases that this expert says they believe matches up with some of what's gone on in this case and Rinderknecht's behavior. The defense is trying to stop that. There's some motioning that's been going on outside of this memo where the defense wants to limit the ability of the prosecutors to say that. And in turn, the prosecution says in this memo they want to block the defense from being able to discuss at all the LA Fire Department's response to the first of those two fires and whether or not the firefighting was effective. Because you'll remember, as we've covered on the news and talked about here, one of the defense's main arguments for why Rinderknecht should not be criminally liable for all of the devastation and damage caused by the Palisades fire is that the defense is arguing the LA Fire Department did a lousy job putting out the first of the two fires and provides an evidentiary separation between the two. We can sort of surmise that what they're getting at is even if you, the jury, believes that Rinderknecht lit the first of the two fires, which the defense does not concede in any way. In fact, they say there's very little evidence that he actually ignited the first of the two fires. But even jurors, if you believe he did, they believe that there is enough of a break in the chain of evidence that you cannot hold him criminally responsible for all of the devastation and destruction that followed. And two of the three criminal counts really relate to destruction caused by a fire, not the specific ignition of a fire. And so if the defense were successful in convincing jurors of this, it might reduce the potential criminal liability significantly. The prosecution is trying to also stop the defense from bringing in its own expert. There are two arson experts that have been listed. One of them, I think his name is Ed Norskog. He is a retired LA County Sheriff's Department arson investigator. And part of his testimony was going to address the idea that the motives that had been described by federal prosecutors previously didn't really match up with the common themes that are accepted amongst arson investigators about the reasons somebody would go out and start a fire. In other words, they're saying the evidence in this case doesn't match up with the guy who's on trial. They also want to block the defense from bringing in testimony about one of the key ATF agents in the investigation into the Palisades fire. This is a little complicated. It's worth hearing because if the defense is allowed to argue this, it could definitely change the perspective of some of the jurors. One of the lead ATF investigators on the Palisades fire case was also previously a lead investigator on a hugely destructive fire that burned for, I want to say it was over a month, inside a Navy ship while it was docked in San Diego. And the fire was terribly destructive. The government prosecuted a Navy sailor who they said had become, follow the theme here, upset with his place in life, didn't like that his career wasn't going anywhere, his relationships weren't working. And even though they had no specific evidence that this particular sailor ignited this fire, he was last seen in the area where the fire started on the ship, around the time the fire started on the ship. And ultimately, the charges against that sailor were thrown out. I think it was a military trial, but the judge found they were baseless. And it turns out the ATF investigator who put that case together is one of the same ones who put the case together against Rinderknecht. And so the defense wants to be able to argue to jurors that they are taking the framework from the San Diego case and applying it here, and there was a major lack of physical evidence in both of these cases that the defense says is really strong enough to link the person accused with the actual ignition of the fire. Seems like it would be a stretch for the judge to allow that, but it may also have to do with what it is that this particular ATF agent says while they're on the witness stand. So that remains to be seen. There were a bunch of orders, I should mention, that were filed in the case where it looks like the judge ruled on some of these things, but they're under seal. So we may not find out until the trial actually begins. Lastly, the prosecution memo lays out a bunch of the prosecution witnesses who may come in. There's someone, I believe there's an ATF agent named Derek Hill, not sure if it's the same one I'm talking about, to testify about the origin and cause of the 2 fires that burned in the Pacific Palisades. Another ATF employee, Jonathan Buta, to testify about the lab work and analysis that was done that helped them reach the conclusion that the origin of the Palisades fire was really the previous Lackman fire. Another expert to come in and testify to say that power lines were ruled out completely about having contributed to the cause of the Lackman or Palisades fire. A cell site expert, probably someone from the ATF or maybe another federal law enforcement agency, to testify about what the feds have said is really critical information that they say puts Rinderknecht right in the area where the fire started, on the night it started, at the time it started. There is a DNA expert who's going to come in and testify about the analysis of a Bic lighter. Let me pause there for one moment. If you remember, if you've been following this case, way back when we first got indications of what it is that the ATF concluded about how this fire was started, there was no physical evidence left at the scene that would explain the ignition of the Lackman fire, the first of the 2 fires. There was no burned anything that would suggest how the fire started. And by ruling out all of these other ideas, you reach the last remaining possibilities if, in fact, you believe this is the guy who did it. Arson investigation is often a process of exclusion. You exclude lightning, you exclude power lines, and then what are you left with? And then you make the leap to whatever it is that you believe happened. And in this case, they say it was an open flame, meaning something that produced a flame like you'd see at the end of a candle or the end of a cigarette lighter, but whatever that thing is, they don't have it. How they know it's an open flame and not something else, again, sounds like it's the exclusion or the absence of other evidence more than anything specific. So when the ATF is investigating the case and they search his car and they search his apartment, they find a Bic lighter. They do DNA analysis on it, and lo and behold, it's his lighter. I believe he was a smoker, and so I'm not sure how much weight they want to put behind this Bic lighter as being the hinge of this entire case. But it seems like the feds, based on this pretrial memo, are putting a lot of emphasis on the fact that the fire was started, we think it was started with an open flame, and we found a lighter. And not only did they find the lighter, but one of the witnesses is going to testify that some of the fuel in the lighter was used. And that is going to contribute to the prosecution's belief that he used that specific lighter to light this specific fire, absent other evidence. We've talked a lot previously about witness accounts that fireworks were going off, because remember, the Lackman fire ignited right around midnight on New Year's Eve, January 2025. And so, yeah, people were setting off fireworks. There were, according to the defense, more than 20 witnesses who were there who either saw flashes or heard fireworks going off, including an LA City firefighter, a security guard who worked in the neighborhood there, and a bunch of residents. We did a news story not that long ago interviewing one of them who was there and hiking on a different trail because he went to go see if there were fireworks. And hears a boom, turns around, sees a flash, and then right where that happened, or I should say, he saw the flash in the fog, turned around after the boom, and then right where he thought it had come from, he sees the flames beginning in what became the Lackman fire. The feds have said absolutely none of that is true. There are no witnesses who saw anything about fireworks, and they say that all these people the defense are talking about must be lying or don't know what they're talking about. And they also say that the defendant himself, when he was questioned, said, "I didn't see any fireworks." They are bringing in a witness to testify that fireworks did not cause this, a guy named Kevin Miner. I don't know if he's another ATF person or somehow has some other insight into how they ruled that out. I'm really curious to hear about that because clearly this is something where the defense is going to put in a lot of time. And then lastly, a doctor who does behavioral analysis to testify about common traits of arsonists. And it sounds like this testimony may be brought in to counter one of the defense expert witnesses, and they're arguing back and forth, the defense and the prosecution, about the scope of the testimony of each of these people and what the witnesses will be allowed to be asked about in court. And then the prosecution also plans to bring in somebody to testify about a rap song, a French rap song that they allege the defendant was listening to, Rinderknecht was listening to, that again plays into a potential motive or a reason for starting a fire. I'm not sure. All right, lastly, before I go, I just wanted to mention Nick Reiner. Nick is the son of Rob and Michele Reiner. Rob Reiner, the movie director, his wife Michele, the photographer, both of them murdered in December 2025, and Nick Reiner arrested less than 24 hours later, now charged with 2 counts of first-degree murder, special circumstance allegation of committing multiple murders, and a special allegation that he personally used a knife to stab his parents to death. The case had gone quiet for quite a while. Right after he was arrested, he has this pretty high-powered, I don't want to call them powerful, lawyers are all the same, but highly paid and well-known defense team, including Alan Jackson, maybe the most sought-after private defense lawyer in the country right now. They began the defense of this case by pursuing some of their own investigation shortly after he was arrested. It sounds like it had to do with issues involving Nick Reiner's past with mental health issues and possibly drug use. Then Alan Jackson and his team withdraw from the case, and now a deputy public defender, Kimberly Green, is handling the case. She withdrew a lot of the motions and subpoenas that had been brought by the prosecution, or I should say brought by the previous defense team, and we didn't see anything happening in the court file. I go to court all the time to check the files of the cases that we're working on, in order to discover if there's something new, if the defense is making a motion, if the prosecution is, helps us uncover hints about scheduling or where the case may go. And in this case, there's been nothing for months. So finally, Wednesday, the same day that the David Burke was brought to court, Nick Reiner's in court in the morning. It turns out there is nothing going on other than a request for more delays. And Reiner, in pretty strong contrast to what we saw in the Burke case, where the defense attorneys were pushing for this preliminary hearing fast. We want it within 10 days. We definitely want it within a month. In the Nick Reiner case, the public defender has done what we more often see in murder cases, which is to ask for more time. And in this case, they're not coming back to court until September. And the September date now is just to set a date for a preliminary hearing. So I don't think we're going to get a lot of insight into what's going on in that case for many more months. All right, I'm going to leave it there. I know that's a lot. Be sure to follow us on TV, online, and click subscribe here so you don't miss any upcoming episodes. I'll see you next time.